Okay. We also thought this would be a good opportunity to share with you some really preliminary results related to our first look, if you would, at the sentencing risk assessment in practice. And as we know, with COVID and different things going on, this should be viewed through that lens that we're not sure what these patterns suggest in terms of usage currently. And at the end, we'll talk about some next steps that the commission staff will be taking to try to see if we can untangle some of what we learned in this. So just really quickly was our mandate came out of Act 95 of 2010. And we know that staff worked on this for close to a decade to develop and implement a risk assessment tool with the goal to help court determine the appropriate sentences for felonies and misdemeanors, used to evaluate the relative risk that an offender will reoffend and be a threat to public safety. I think that this just worth just emphasizing that the commission decided on a definition of arrest within 3 years leading to a new conviction. There was early discussions just about arrest versus convictions, that the risk assessment instrument may be incorporated in the guidelines. And it's used to determine whether a more thorough assessment is necessary to order a pre-sentence investigation report, and maybe an aid to help determine the appropriate candidates for alternative sentencing, for example, triple RI or boot camp. And then Act 115 of 2019 expanded that to suggest that it may be an aid to help determine for persons under supervision the intensity of supervision, the use of restrictive conditions, and the duration of supervision, and appropriate candidates for state drug treatment programs. So essentially, the recommendation is linked to obtaining additional information to help aid decision-making. Just as a reminder, we had 7 factors that were included in the risk assessment instrument, things like gender, age, current conviction types, each receiving different point values. Those points are summed, and that gives us a total number that can be then used to classify individuals into 3 categories of low, typical, or high, with low being 0 to 4 points, typical is 5 to 11, and high is 12 points or greater. It's also worth noting that our low category includes about 18% of offenders in our construction sample. The typical is 78%, and then our high is slightly less than 5%. This is the scoring of this is automated through SGS Web with information we obtained through JNet and AOPC, and that there is no indication on the guideline form of whether the individual is low, typical, or high. It just notifies on the form for low and high risk offenders, it says additional information is recommended. So again, avoiding indicating whether the offender is low or high risk relative to others. So risk assessment became effective for offenses committed on or after July 1st, 2020. So when we looked at our information or our data, you could see these are risk eligible offenders. Started off slowly in July because these are for people who are sentenced, not arrested or brought into the court system through a new filing. This is actually sentencing. So we had very little in July, August. And as cases started to work through the system, we had more and more risk eligible offenders. The April, May, and June downward trend is the way the commission often receives information from the courts. There sometimes is a lag that we're receiving sentences, let's say in April, for April, it could be even in July. So there's a little bit of a lag, and I think that this, the certification efforts and reminders about that's going on is trying to improve the timeliness of the receipts of those sentences. But you could just see, so that's really an artifact, I think, of just the way the data's coming in, or an artifact of COVID and short staff in courts and different factors that may be contributing to fewer sentences being imposed, or these sentences not being entered and submitted to the commission. So on that point, what this shows is these are the actual sentences imposed during the different months. And so if we look at March 2020 when COVID starts, and then you could see a real downward in April when courts were closed, we just received fewer sentences for those months. It went back up as courts reopened in June, July, August of 2020. And then we've seen, interestingly, a gradual decay. Some of that, again, may be for data that hasn't been submitted to the commission, but some of that might just be the return of COVID and different practices that are occurring in the courts. So I wanted just to now take a look at the instrument itself and be thinking about the information that we did receive for people who were risk eligible currently compared to when the tool was developed. So this is the construction sample, meaning information from 2004, 2005, and 2006. And the percentage of individuals who fall at different risk scores. So when we impose upon those groupings, as I mentioned, we have about 18% in the low risk category, which is our 0 to 4. We have about 3/4 in the typical category and about 5% at high of 12 or greater. So that was our construction sample. So when we take a look now at the 11,000 offenders, 11,500 offenders in our new database of risk eligible offenders, we see that it's pretty remarkable that it does follow this normal distribution, and those percentages are very close. And as we get more individuals who are risk eligible, my guess is it will become even closer to those distributions that the development sample of closer to about 5% high and 17.5%, 18% for low. But it is remarkable that it's normally distributed just as was proposed and thought would be the way it would work in practice, and in practice is following that pattern. So if you remember when an individual is low or high risk, there's a recommendation for additional information, that the court obtain additional information through a PSI or risk needs responsivity tool. We would think that if you were low and high, that then the court would obtain a higher proportion of additional information for those categories. But what we see in practice, again, this is a small sample during COVID, so it's difficult to interpret, but that they're essentially the same no matter what your risk category is. So there's lots of hypotheses about what judges are doing, or are they ignoring that, or how this is working in practice, but or is there just not enough individuals to fill out the PSIs, or they're not ordering them? So we dug down just one more layer, which was just taking a look at county class, and we looked at combining county classes 5 and 8, and we see for 2A that they are using it at a higher rate than the rest of the county classes, and this rate does vary by county if we looked at it, but the ends are pretty small, so it's hard to determine. But again, I think our takeaway here is at least the scoring of the tool in practice and who's being classified as low, typical, and high is consistent with what was developed and proposed and adopted by the commission. In practice, there seems to be somewhat of a disconnect, and what the cause of that is, again, if it's COVID, what types of offenses are coming through the court for sentencing, resources, or judges are just not aware and paying attention to it. We don't know, but I think what our next steps, and we certainly welcome some other input, is to reach out to a few counties to talk to them about what's happening in practice, especially the counties maybe that are using it at higher rates or at lower rates, and talk to judges, maybe some probation staff and others about what's happening and why are we seeing this, or why are we seeing different trends in different jurisdictions.
how do you know judges are getting additional information? I mean, what's reported to you guys, I guess, is what I'm trying to figure out.
A couple things. First, we know that the guideline form includes the notation. So if the judge is seeing the guideline form, and that's a question, right? But if the judge is seeing the guideline form, then it should fit that profile that Matt talked about. And then we ask in our application if the court requested information and so forth, so we gather that. So another decision point is, who is entering the information? Do they have that information that they entered it correctly? And then there's the whole COVID issue. What if you don't have resources? What if POs can't do PSIs? And so there's, this is not like the best time to do an analysis of a new program, but we didn't really have that choice. So there's just a lot of open questions. So I think, as Matt said, we'd appreciate any thoughts, and maybe, at least for the 4 judges on the commission, maybe we can figure out a way to talk to you or to your bench about, or your probation department about just what's going on. And we have a sample of 4 then to look at and try to figure out if we can have any takeaways from that, figure out what's going on. Because it might be bad reporting, but it could just be no resources at this point, or,
Do we define what additional information is? I forget how we...
We recommend in sort of the text of the stuff, an R&R PSI. So PSI that includes risk, needs, and responsivity. But we leave it pretty open-ended. That's actually another sort of data question, because, we ask information about PSIs and other information generally on guideline forms, and we ask about the stuff with the risk assessment. AOPC gathers that stuff through CPCMS. And so one of the things we've been trying to do is look at what AOPC has and whether that's changed, because maybe that's more reliable or at least standardized, because we've inserted a new practice, but from AOPC's point of view, it should be the same kind of reporting. But they're stuck with the same issue of COVID as well. So is it that courts just aren't operating, or the cases coming through are different, or you don't have the resources to get the other information? So
how hard would it be to put together a simple 1-page online survey with, that list of reasons?
People that can do that.
but then, and literally send it to the judge and say, like, in a gentle way, but, the risk assessment instrument recommended you obtain additional information, whatever. It was reported that you didn't obtain any information. Sure. Could you help us understand why that was, to better inform our practices, or some gentle,
that's a great idea,
way to at least get some feedback. And because, I don't know, you guys, judges can tell me if I'm wrong, but I feel like some of this, just in the COVID world, it may just be a complete oversight. They may not even realize it. And just getting that survey might prompt them to say, like, wait a minute, what's happening here? And then become better informed on it.
It's very possible. Now, Ryan's staff has been doing a lot of work, meeting with counties, trying to push all kinds of things, including this, because that was part of our rollout. But you're right, in the mix of everything, could have gotten lost in the shuffle. So first, I think that survey is a great idea. I think it may be helpful sometimes in creating a survey, having like some information. So having discussions with the 4 judges, or discussions of practices in your counties, just to make sure we're asking the right questions in the right way, could be pretty helpful. But as I said, I'm really happy to pass this off to Matt and company, our research partnership, get Ryan involved. Ryan?
Just one other thing to add for the members. I think the judge pointed to it. Some of the counties are going through process changes, which might impact whether or not the judge actually receives that recommendation at the time of sentencing or prior to sentencing. So, for example, a county who completes guidelines after the fact, in the system, in SGS Web, you would assume the answer to that question would be no, because they're not receiving the physical guideline form being created by the SGS Web application, which is required to generate the assessment. But we've seen a big shift with a lot of counties, and a lot of larger counties as well, where they're moving that process to the district attorney's office, which then my assumption would be, which is wrong of me to do, but I should presume that those answers would start to become yes, that they received at least the recommendation than doing it on paper like they have been for 25 years. So we've made a lot of progress in that area.
Absolutely.
So I'll just add one minor thing, which is, yesterday we were talking about the memorandum of understanding with Penn State University. So we leverage their survey technology at the commission through Penn State. We can do these web-based surveys. So it's just a nice service that we get through, the liberal arts group at Penn State, so.
That's great. Hey, if we can wrap this up, we're about 5 minutes from the end of the meeting, and I know we want to talk about scheduling our next review of this information. So if you have anything else, Matt?
Nope,
Okay.
perfect, thank you.
So maybe,
Mark, let me,
yes,
if I
Judge.
may, I think the
Please.
survey is a good idea. However, knowing my bench, I can't speak for any other county. I think you'll get some defensive responses as opposed to something that's candid and true and accurate. My thought would be either a sit-down, a telephone call, or something of that nature that can be arranged by me or the current supervising judge for criminal. I think it would be more accurate as opposed to a question, why didn't you, or something of that nature.
Sure.
These
Yep.
judges would be very defensive and perhaps give you information that may not be as candid and accurate as we would want it to be. But I do think communication with the judges is an excellent idea. But I just don't think it should be a survey. I think it would perhaps should be more personal. And I think the information would be more true.
Okay, thanks, Judge. We'll at least do a two-step process. The first step will be to reach out to you and the other judges on the commission and have meetings with your bench or just discussions to sort of do exactly what you said, try to sort of understand what's have a conversation about it. And then based on that, we'll figure out what the next step is. If we're doing a survey, who it's sent to, what it looks like, make sure it's not accusatory or anything like that. So I think that's really helpful. So appreciate that.
Yeah, we meet almost once a week for CJEs, continuing judicial education. So it's very common for us to get together by Zoom or in person. And it's easy to invite staff from the commission by Zoom or some other mechanism to meet and just ask questions or just have a conversation and lace that conversation with the questions that you want answered. Again, having supervised 40 or so criminal judges, it's sometimes not as pleasant as you'd like it to be, and the responses are not as forthright as you would want them to be. So I think we just need to think about how we want to do this as opposed to something that can be interpreted as something accusatory.
Sure. Great. Thanks, Judge. Matt, anything else? Great.